Good afternoon. My name is Greg Bloom, and I'm a partner director at Garfunkel Wild and the co-chair of Garfunkel Wild's corporate department. I'm joined today for our session on MSO-PC relationships by my colleague, Kathleen Brown. Kat is a senior attorney at Garfunkel Wild who handles a broad spectrum of healthcare regulatory and compliance matters. Before joining Garfunkel, Kat held numerous positions in both private and New York State government sectors, giving her diverse perspectives with which to assist our clients. We're also thrilled to have Taylor Burns, who is a senior manager at Withum and the leader of Withum's Healthcare Valuation Services group. Taylor has extensive experience in advising healthcare clients on valuation as well as related guidance for transactions and litigation support. During today's session, I'll be asking Taylor and Kat a series of questions to guide our discussion on MSO-PC relationship, with the intention to provide you with guidance as to issues to watch out for, how to value MSO services, and related matters. So, to lay the groundwork for our discussion, we know that the MSO-PC structure is often used as a way for non-physicians to participate in the economic benefits of a medical practice. But we're also aware that many states prohibit the corporate practice of medicine. So, Kat, how can one structure an MSO-PC relationship to navigate the restriction on corporate practice of medicine in these states?
Thanks, Greg. So that's a great question. And the key is to clearly separate out the roles and responsibilities of the PC and the MSO. The PC, as everyone knows, must be owned and operated by licensed clinicians. And that PC will at all times retain sole responsibility for all clinical decisions, patient care, and clinical practices. This ensures compliance with CPOM, or the corporate practice of medicine, by making sure that the clinicians maintain full control over the clinical aspects of the practice. Meanwhile, the MSO handles the non-clinical or business side of things. This can include things like the administrative functions like billing or HR, marketing, and office management. MSO may also handle payroll or lease office space to the PC on the PC's behalf, provide non-clinical staff like receptionists or medical assistants, or license proprietary technology to the PC through a technology license agreement. So if you think of it, the MSO's role is essentially to manage the day-to-day operations or the back office while allowing the clinicians the time to focus solely on patient care, the most important thing that you want your clinician focusing on. Right. So by keeping this clear separation between clinical and non-clinical roles, the structure allows the non-physicians to participate in the economic benefits while not infringing on the legal boundaries set by CPOM.
Great. So what legal safeguards do you generally put in place in these deals so that the MSO doesn't exert improper control over the clinical decision-making of the medical professionals?
Right. So it's very essential to have that relationship very clearly define these roles. So it's essential that the PC and the MSO be governed and their relationship be governed by a clear written agreement. So this is typically called a management services agreement, or MSA, although you might also hear referred to as an administrative services agreement. But regardless of the name, the agreement clearly defines the roles, the responsibilities, and outlines the business functions that the MSO will handle. Like I said, like the billing, HR, administrative tasks I mentioned earlier. So, but most importantly, the MSO should also include boundaries that the MSO cannot cross. So, for example, an MSO should never be given the authority to make clinical decisions. It seems kind of common sense there.
Of course.
But also shouldn't be, have any influence over determining treatment plans, ordering tests, or deciding what procedures should be performed. And that importance, that clinical decision making, should always remain firmly with the licensed clinicians, and the MSA should clearly state that. So
Great. And I'll add, I know I asked about the clinical decisions, but we've seen cases such as Aspen Dental, and obviously commingling of funds and
Yep.
business operations need to remain totally separate, so that a regulator doesn't collapse the entities and say that the management company is really running the entire show and not just.
Yeah, exactly.
Okay, so Kat, we know that the MSO and its non-physician owners can't practice medicine. You've made that clear, but they often ask us and their other advisors to protect their quote unquote investment by using non-compete clauses or restrictive covenants. What can you tell our audience about using non-compete clauses in these types of arrangements?
Yeah. So, this is a great point and something we deal with all the time. And as I often tell our clients, and unfortunately, it's the classic lawyer answer, it depends. Um, Restrictive covenants and non-competes appear in MSAs all the time. And can they be included? Sure. But then it becomes the question of whether or not they're enforceable. And that's an entirely different matter. The key lies really in how narrow and how reasonable that restriction is going to be. So, for example, if a non-compete clause in the MSA tries to prevent a clinician from practicing their practice, their licensed profession entirely, it's highly unlikely that a court would enforce that at all, especially in states that are very protective of a clinician's right to practice, like New York or California. That's why we don't even recommend including such language in any agreement because, it's just it's just easier to leave it out. Now, on the other hand, though, if a clause was focused more on protecting the business interests of the MSO, so for example, preventing a physician from starting or working with a competing management company that targets the same client base or uses similar proprietary business methods, there's a stronger argument for enforceability then, and that kind of restriction generally would be more of an interest of protecting the MSO's investment in infrastructure or systems and know-how rather than restricting clinical practice. So, like I said, there's a stronger argument there. At the end of the day, though, the enforceability of that restriction is always going to turn on the specific facts and circumstances of each individual instance. So really, when trying to put those in place, it's really important to talk to your legal counsel to, make sure that you're marking out that path as best you can.
And building on that, what I often tell clients, if they're on the MSO side, the cases say you have to have a protectable interest,
Right.
and if you can't practice medicine, which the owners of an MSO can't, they're not licensed. If they're not licensed physicians, they don't have a protectable interest to prevent the providers from practicing in their profession. So
Exactly.
I agree. We can generally prevent them from providing the same type of management services, but not the clinical.
Right.
So in our short time, we've briefly covered the corporate practice of medicine, but we also have to be careful about fee splitting prohibitions in these types of structures. So Kat, what constitutes unlawful fee splitting in an MSO-PC relationship, and how could we avoid running afoul of these restrictions?
Yeah. So this is probably one of the most important issues and one we deal with all the time. And, also one that obviously is very important to our clients. How at the end of the day am I going to get paid for what I'm doing? So unlawful fee splitting, as I'm sure many of our audience is already aware, but just for everybody's benefit, unlawful fee splitting happens when an MSO or a non-clinical uh, individual or person or entity receives a cut of the revenue generated by the clinical services provided by the practitioner. So, for example, unlawful fee splitting might be something like if the compensation structure was set up that the MSO received a percentage of all reimbursed services that a PC provided. Now, at first glance, tying compensation to revenue seems like a logical business arrangement. But from a legal standpoint, it raises many red flags because, and most importantly, it could potentially create or even have the perception of creating financial incentives on the part of the non-clinicians to influence or pressure legal decision making, which not only undermines clinical independence that we keep talking about that's so important, but also puts us right back where we started with, is that violative of the corporate practice rules? So with that, the safest path is to ensure that the MSO's compensation is based on actual legal non-clinical services. So again, those billing, IT support, office management functions we talked about earlier. Another important aspect of the compensation, and something I know Taylor's going to talk about in greater detail, is that the fees should be commercially reasonable, consistent with fair market value, and structured in a way that's not tied to patient volume, revenue, or clinical outcomes.
Great. Yes. And I will add, and as you said before, speak to your advisors, whether it be your accountants, financial advisors, your attorneys, because there are certain states that do allow other compensation methodology, but there are a lot of states that prohibit fee splitting. And when you have a big practice that goes across states, we generally structure it to be compliant with the most restrictive rules that govern. Um, so Taylor, we've seen more private equity-backed MSO-PC structures in the past few years. What are some red flags that you want your clients to look out for when dealing with these structures?
Good question. Some of these tie back to these common compliance issues that typically arise. One area to look out for, particularly, is fee structure problems. So, for example, if the MSO fee represents an excessive percentage of the practice revenue, the thing to look out here for is what practical effect does the fee have on medical profits, and what is it indicating with respect to functional control? The same would go for any type of staffing function. Is there a functional control by the MSO over clinical staff through things like recruitment, firing, productivity quotas, anything that suggests or imposes clinical best practices by the MSO, or suggests or undermines physician autonomy in medical decision making, really needs to be looked at. Other areas of financial control to look out for would be things at the billing level. So, for example, if the MSO is billing and collecting fees directly from patients, that could be a problem area as well. I think lastly, I would say that any other measure in the agreement that somehow restricts the physician's ability to exit the relationship without exposure to litigation, that would represent an overreach as far as corporate practice in medicine goes.
Okay, interesting. Well, it sounds like you and Kat are on the same page. You reiterated a lot of the things she's already said. So given the complex legal and financial considerations in an MSO-PC relationship, how can legal counsel and financial advisors collaborate to ensure the relationship is structured in a way that's both compliant and financially sustainable?
I think financial advisors and legal advisors need to be on the same page with respect to understanding what the subject PCs are doing and what they're expected to do. It's a lot easier for the financial advisor to go through the valuation process when the structure in place has already been blessed by legal, so to speak, when those legal guardrails are in place. But I think the way that the financial advisors can help legal is providing a clear picture of, not just what the PC is doing, but what is it expected to do? How are these levels of physician productivity being measured? What is a reasonable level of activity and productivity to anticipate going forward, given the overall, let's say, patient need in the community? Because what you don't want to do is you don't want to enter into an agreement and assume that certain dollars are going to be generated by services that are not sustainable, or, as we would say, not commercially reasonable.
Okay, and we're going to get into that. I know you speak about that quite a bit. So, as our valuation expert, Taylor, we're going to turn specifically to valuation of these structures. We all hear about making sure a deal is fair market value. Fair market value. The attorneys speak about that all the time. But I know that you often refer to other standards, such as the volume of value standard and the commercial reasonableness standard. Can you tell us the difference among these standards?
Yeah, so these are separate and distinct standards that arise out of Stark Law. The audience is probably most familiar with the IRS definition of FMV. The Stark Law definition echoes the IRS definition. For our purposes, FMV is a quantitative assessment that looks at value through an agnostic lens, i.e., from the perspective of any willing buyer or seller. The volume or value standard So that's referring to the general Stark Law requirement that compensation within an arrangement is not determined in a way that takes into account the volume or value of referrals for designated health services, specifically by a physician who is a party to that arrangement. As a compliance requirement for MSO-PC arrangements, the question here is essentially, is there a mathematical formula in the compensation that includes designated health services or referrals for such as a variable? And if so, then does that compensation increase or decrease based on a positive or negative correlation with the referrals or other business generated by the physician who's a party to that arrangement?
Generally a no-no.
Yeah. And these violation thresholds here. These are bright line thresholds that are, laid out in some detail by CMS. So this is something that can be measured. Commercial reasonableness is probably the least understood of these three, but this is essentially the defined requirement that arrangements are sensible based on actual party characteristics, and that they further a legitimate business purpose. As a concept, commercial reasonableness is often commingled with fair market value. But unlike fair market value, commercial reasonableness is not a question of valuation. Rather, it's a question of what is the justification for the entire arrangement in the first place, based on the actual parties involved. From a federal perspective, all three of these standards need to be satisfied when incorporating MSO-PC arrangements.
Right. Very helpful. And just as examples, we've seen in the past, for instance, the leasing of space, commercial reasonableness comes into play, where someone who may be receiving referrals from someone else wants to lease space, and they're going to, even though they're only going to use the space 1 day a week, they'll lease the space for 3 days, and obviously that's unacceptable and not commercially reasonable. The OIG would say that is a violation. So that's one of the places where that comes in. So Taylor, thanks for that separation of those standards. Now that we understand the differences, what are some of the questions at focus in a commercial reasonableness assessment? And does the consideration of commercial reasonableness impact your determination of fair market value?
Yeah, so some of the questions at focus here would be, does the arrangement satisfy a legitimate business purpose? Does it avoid separate duties, or does it appropriately separate duties and avoid duplicative efforts? Does it make sense when compared to other alternatives? Is it consistent with the strategic and financial goals of all parties? Is it consistent with the value of services that are being provided? Conceptually, this can have a procedural impact on FMV, especially when it comes to determining which methodologies to apply in evaluation. Practically speaking, I think considering commercial reasonableness can help explain or sometimes justify operating losses that might be present in an FMV analysis. In a sense, I would say that commercial reasonableness sets a higher bar, which can either validate or invalidate an isolated fair market value analysis.
Okay. Helpful. And can you give us some examples of MSO-PC arrangements that may violate commercial reasonableness?
Yeah, so the lens to think about this through is, for an MSO-PC arrangement to be commercially reasonable, it needs to not just satisfy the FMV requirement, but also resolve a legitimate business objective without creating duplicative or unnecessary functions. So an example here would be, you might have an MSO-PC model that is providing non-clinical staffing in return for a fee. Maybe that fee aligns with FMV. But if those staffing functions are already handled in whole or in part by the PC, the arrangement's not going to be considered commercially reasonable. Another example would be a
great example. I've actually seen that in practice.
I have too. Just doubling up on efforts. Yeah.
Right.
Another example would be, okay, you have operating losses that are incurred for no legitimate reason, especially if you have operating losses as a function of high compensation to any providers that are part of the picture. That would likely also be an FMV violation as well. I would say in general, as a rule of thumb, any arrangement that is overly ambiguous, difficult to follow, or resembles something that isn't found elsewhere in the marketplace ought to be looked at.
Okay, thank you. So Taylor, are there different valuation considerations that you take into account for different types of MSO-PC structures?
There are, depending on the structure type and the scope of services that's involved. In the case of a conventional model, where maybe you have stabilized operations, you have a discrete number of specified MSO functions, the focus is largely going to remain on measuring and valuing those identified services. In the case of a model where you have where stakeholders are expecting a lot of growth, the valuation is going to consider what the efforts of the MSO look like over time. So that may include certain scaling considerations or tiered cost structures. As you move into more complex models where you have multiple PCs, exchanges in equity, additional service agreements, and even sub-MSOs, it becomes even more important to look at each component of consideration separately, while not losing sight of the understanding the flow of funds across the entire structure. Ensuring that provider compensation is commensurate with F&B will definitely play a larger role when you have more and more physicians in the picture. It's also important to, especially when dealing with larger platform models, that the service scope doesn't include anything that would create a regulatory red flag down the road. I think a good example here would be an arrangement that has some sort of volume-based marketing component. The provision of marketing services is often formalized with ambiguous language, which makes it easy to use that service offering as a vehicle to hide referral activities. In these cases, from the valuation perspective, the treatment of any marketing component would need to be handled in a way that avoids attaching a value to a commission-based effort.
Okay. So one of the biggest considerations when we have these structures is what in the world is the management fee? How do we value that? Especially hard in startups. So what's the typical process for valuing the MSO fee in these structures?
So a standard fair market value analysis is generally going to take a bottom-up approach and examine the MSO fee through the lens of what is the cost to recreate these services with a reasonable market margin. The scope of services will ultimately dictate the specifics here, but you could lay this out in 4 steps or stages. The first step, and often the most involved step, is going to be determining the actual or expected MSO expenses. This would include capturing and allocating all costs associated with the provision of services, accurately accounting for time and effort of MSO personnel, and normalizing those expenses where appropriate. This is typically the most involved step, especially when you're dealing with startups or high growth structures. Generally, there's going to be more of a pro forma development or a consideration of what things are going to look like, not just today, but 6-12 months down the road. The second step here would be to assign line item expenses that have been identified for the MSO into distinct categories according to type or related service. The idea here is that each assignment represents a unique category for which market data can be compiled. The next step would be to compile margin data applicable to each of those categories. So this would ideally include data from comparable public companies, various industry publications, and transaction databases. That would bring you to the kind of the fourth stage, which is taking these margins that you have pulled and calculating corresponding markups for each of these designated cost categories. These markups, they're not one size fits all. They do need to be consistent with the service components of the subject arrangement. And professional judgment does play a role here. At the end of the day, the question we're trying to solve is whether the fee that is being paid to the MSO reflects a market-derived markup on costs consistent with those of similar outsourced services across the industry. CMS does provide leeway here. It doesn't impose a specific methodology requirement, nor does it impose any sort of established cap on the level of management fees. But there does need to be support from external data to satisfy the FMV requirement.
So the long and the short of it is call Taylor, get a valuation consultant, make sure you're looking at all of these things. And can we rely on, sometimes we say, oh, I know this management company is charging X. Can you rely on publicly available management fee data?
A straight market approach is helpful if you're looking at certain cost categories. For example, what is the market equivalent compensation for the efforts of MSO personnel? It becomes less applicable when you're trying to determine the fair market value of the fee itself. There are market data points out there that you could pull. Management fees as a percent of revenue. The primary challenge there has to do with comparability and transparency. A lot of times those data points, just as an example, MGMA cost and revenue database, you might be able to find a common size data point for management fees as a percentage of practice revenue. But the problem with a data point like that is it's not going to provide insight into the services that are being captured in that underlying data point. So it may not be comparable to your subject arrangement, that has a specified scope of services. If you are dealing with a more comprehensive service scope, the market percentages that you're using may actually understate the value of your subject arrangement. In these cases, I think that's why it's more meaningful to start with a bottom-up approach, look at every service component individually, and then maybe you can use comparable agreements as a sanity check. But it's really difficult to rely on those primarily for the lack of comparability and the lack of transparency.
I would agree with that. Makes a lot of sense. So Taylor, Kat and I both face this when we tell our clients, this has to be fair market value. We need to get an outside valuation. We advise them to go seek that. They're generally pretty understanding. They want to be compliant with the fair market value standard. So they hire someone, they get the valuation. They're okay with that the first time. Comes around, an event comes and we tell them that they should get an update for the next transaction that goes up, and they never really want to spend the money a second time. So I guess the question is, how long do these valuations last? How long could you rely on one?
FMV opinions are generally as static as the underlying operations. In reality, the fair market value of an arrangement is going to change over time due to market dynamics, due to industry trends, due to changes in service scope, then just due to changes in the PCs that are being managed, as their revenue streams fluctuate, for example. I would generally advise that FMV is re-examined on a periodic basis. I would say maybe either once a year or each time the MSA is renewed or updated, whichever comes first.
I would agree with that. I usually, at least mine and Kat, I usually say after a year, you really have to get another one.
Yeah, agreed.
But it could change more frequently. So I know we only have 30 minutes. We have give you one last question. A few seconds remaining. And I started out by saying that we usually use these types of structures to allow non-physicians to participate in medical practices. What are other platforms? What examples why someone would use an MSO-PC structure?
It could be used for asset protection. The idea here is that the MSO can shield certain assets from various PC liabilities. You can have certain non-clinical assets of the PC legally transferred to the MSO, who in turn then leases those same assets back to the PC. This strategy would basically allow the PC's physicians to offload the burden of maintaining and replacing their equipment. You could also use this to align strategies of a senior physician partner who owns and operates a practice with a junior partner that he's looking to bring on. You could have a founding doc set up an MSO, enter into an MSA with the practice, and then allow this junior doc to buy into the practice. That allows the senior doc to maintain control of the management and administration of the practice. It can also help resolve a disconnect in the perceptions of value that both doctors have on the practice itself.
Okay, interesting. And thank you both. Thank you, Taylor and Kat, for all that information. And we're short on time, but there is a question and answer session that follows immediately. If our viewers have additional questions, we will be on that and be happy to answer those questions. So thanks again for joining us.
Thanks, Greg.
Thanks, Greg.
Thank you.